Welcome to Penn State Dickinson Law's Profiles in Leadership series. I'm Daryl Lim. I serve as the H. Leddy Montague Jr. Chair in Law and Associate Dean for Research and Strategic Partnerships. This series explores leadership through the eyes of judges, lawyers, policymakers, and institution builders as they reflect on their journeys and the lessons they have learned along the way. It's an honor to welcome today's guest, Dr. Francis Gurry. He has spent his professional life at the center of the international intellectual property system. He joined the World Intellectual Property Organization and served in a remarkable range of roles, including as Director General, where he led WIPO through a series of extraordinary change, where he's witnessed the globalization of innovation, the rise of Asia as a major center of IP activity, the growth of digital markets, and the growing pressure of multilateral institutions. WIPO also concluded major treaties during that time, including the Beijing Treaty on Audiovisual Performances and the Marrakesh Treaty to facilitate access to published works for persons who are print disabled. He also helped to move WIPO into new conversations about innovation measurement, development, technology, and artificial intelligence. It's a privilege to welcome you to Profiles in Leadership.
Thank you very much, Daryl. Well, look, it's my privilege to be on your program, a wonderful program, and to be with you and have the opportunity to have a conversation with you again.
Thank you. I'm very much looking forward to it. So let's start at the beginning. Looking back at your early life, at your family, at your education, your time in Australia, what do you think most shaped your values and your sense of the wider world?
Well, I was born in Melbourne, in Australia, as you know. I was number 6 of a large family of 7 children. So I suppose being one of 7, which is a rarity these days, teaches you the necessity of cooperation, compromise, and loyalty, really. So they were major, I think, influences that came out of the mere fact of being one of 7. Together with, I think there was a strong work ethic that was imposed by my parents. The world was not as prosperous in those days as it now is. It was emerging still from the devastation of the Second World War, and getting on with things and working was extremely important. And Australia was really still a young country, even with a very ancient Indigenous population.
Thanks. And so you decided at some point that you wanted to do law. What drew you to the law, and how did your time at the law schools, the legal institutions that you were in, how did it shape your way about how you thought about the law and legal institutions in general?
Well, I wish I had a great answer, like I had a passion for the law from the age of 5 and I followed it through. But the reality is, well, that was not the case. And I rather did law by a process of elimination. That said, however, the more I became accustomed to law and the more I studied it, going right through the various degrees, the more I became attached to law and found it to be, such a crucially important force in society. And I think we see that more than ever right now in the contemporary world. Without law, we are really in the jungle and fighting one another. So it's a passion that has grown, really, rather than having had the foresight to see it.
How was law school like when you were there?
Well, it was very different. It was not as, I think, it was not as pressured as it now is. Law students, I think, now are under a great deal of pressure. In my days, it was the whole university environment was a little bit more relaxed. We had some great teachers, of course, in the various universities that I attended. It was not you were expected to do the reading before class, but a lot of people didn't. You would not get away with that now. So it was, I'd say, more relaxed environment when I was a student.
So you went to the University of Melbourne, and
Yes.
as in many other places, there's a great rivalry, I think, between the best universities in the country. Tell us how you decided which university you went to, and why not the other?
Yes. Well, Australians are not very itinerant. If you take a country like the United States, as you know better than I, people often travel interstate for universities. We don't tend to do that so much, or did not tend to do that so much in Australia. So the natural place was Melbourne. I was born in Melbourne. I did my secondary school in Melbourne, primary school, and so you went on to university, and it was University of Melbourne then. Now there are many more universities there, but in those days there were only two really, Melbourne and Monash. So you didn't really think about going interstate, and the possibilities of going overseas were also much, much, much more limited. I really envy students now who have all these exchanges, semester exchanges. It's a wonderful thing for broadening, but then there was really not much choice.
So talk about what happened after you graduated.
Well, after I graduated, I did what was called articles of clerkship, which is like internship at a law firm, and then qualified to practice, and practiced for a period of about 2.5 years, which in a law firm, it was a great law firm. It used to be called Arthur Robinson and Co. It's now known as Allen's, I think. And that taught me so much, because you go from a rather academic environment to one in which you have real life problems, and you have to apply whatever you have managed to retain to the real life problems, and you enter into a period of problem solving. And there were some great professionals who really helped me considerably. Then after that, I went and did a doctorate at a PhD at the University of Cambridge in the UK. And I was fortunate to have a great supervisor, and Gareth Jones, who was an expert in restitution. It was a wonderful environment. When I look back, I think I didn't have the foresight to see how lucky I was to be in that environment. It was really a tremendous academic and intellectual and social environment in which to spend 3 years. So I did that, and I worked on confidential information, the protection of confidential information. And I came to that area really because at that stage it was not so well described structurally in English law and in various other common law jurisdictions. In the US it was, of course, but in other Commonwealth jurisdictions, Canada, Australia, Singapore, New Zealand, and so on, it was not quite so well described. And there were some thorny doctrinal issues about the interrelationship of contract, equity, and to some extent property, and what was the proper jurisdictional basis of this action for breaching confidential information, breaching confidence. And as I got into that, it was the period, this was the end of the 1970s, it was the period in which the study of law and economics was becoming popular, pioneered in particular by the University of Chicago lawyer Richard Posner and others at the University of Chicago. And there was legislation for the Supreme Court of the United States, litigation rather, before the Supreme Court of the United States, which concerned a patent license. And the question that was raised was whether state law, as it then was, for trade secrets, protecting secrecy, was compatible with federal law of patents really promoting disclosure of technology, or whether state law was unconstitutional in view of preemption of federal law of disclosure. So I studied all the amicus briefs that were, I think it was about 1,600 pages of microfiche at the time, and studied those. And part of the thesis, it was a legal and economic analysis, and looking at the economics of trade secret protection, which was very interesting, I found. And as a matter of fact, I did a survey of British enterprises at the time and got quite a good response rate, about 27%, I think. And it came out that, up to 30% of them were keeping secret potentially patentable inventions, mainly in the process area. So that that interaction of trade secrets, as it were, confidentiality, and patents brought me into the broader field of intellectual property. So I would say that most things in my life have happened by accident rather than by design. I can't claim any great foresight, and I was just lucky to get, these successive breaks into new fields.
Well, and you trimmed your sails as you caught the wind. Fascinating response, which invites, I think, a few follow-up questions. So I'm going to ask you the questions in reverse order. Uh, let's first talk about your study of the amicus briefs to the Supreme Court, 1,600 pages of microfiche. People that I meet in various parts of the world can't help but refer back to what's happening in the US jurisprudentially, and it seems like that was also the case back in your day. What do you think is characteristic? What characteristic would you say it is? Quality, maybe, is a better word, about the US that makes foreign observers so interested in what's going on here?
Well, I think it's the underlying technology. The US, having been for the greatest period in, let's say, the post Second World War, at any rate, the technological leader of the world, the sort of questions that are posed in the US preempt the rest of the world. They're before the rest of the world. So we often see that a question is being raised in the US in jurisprudence, in case law, because companies have invented new technologies, and those technologies are being tried in the marketplace, and collisions occur in the marketplace. I think that's the primary reason. Now, of course, we're seeing, as you mentioned at the outset, a change in that China has, risen extraordinarily, and not just China. You must mention Japan as having been a strong technology power, and the others that I mentioned, going down in Asia. So that is going to produce, I think, a greater emphasis on what, for example, Chinese courts are deciding in the field of intellectual property, because increasingly, whether it's battery technology or some other field in which the Chinese may be leading, some of the green technologies, that's going to produce marketplace collisions and questions of jurisprudence, as they say in civil law, or questions of case law, which will come before the courts. And it'll cause a little bit more emphasis, I think, on the court decisions that are being taken in China, even though it's a civil law country, of course, and the case law is not as important as it is in common law countries. But going back to your question, the US, because of its technological leadership, has been the place where the questions first arise.
So it's interesting you used the word preempt initially when you talked about the US, and it's probably true that in many cases you see a mirroring, if you like, of the way that US courts approach certain issues, certainly in Western countries, and maybe even in other parts of the world where the US has signed trade agreements. So through the instrument of trade agreements, exported.
Darren, I'm sorry, I just lost that question. It
Sure.
didn't come through. Yeah.
Let me backtrack. No problem.
Yeah. Thanks.
So we talked about preemption and how the US seems to have an outsized influence on what's going on jurisprudentially and legally the rest of the world. Do you think that people are looking to the US and saying this is what the US is doing, this is what we should be thinking of doing, or is it much more diverse? And if so, where are the centers of gravity today?
Yeah, look, I think the US it remains a center of, attention. It does attract everyone's attention. We often see them framing questions for the first time. But as I said, I do think that there are other centers. We can't neglect Europe, of course. It may be behind US and China in terms of technological leadership, but it's got a very strong cultural basis, of course, which is exceptionally important for copyright and the questions that are arising in copyright. But if you look at the collations of cases on one, major issue that we're all aware of, which is the question of the legality of training AI models using copyrighted data, I think that you see that in the United States there are around about 110 cases covering this question right across the United States, the various jurisdictions in the United States. Now, the next most populous number or greatest number of cases on that issue is China. And in China, if I'm not mistaken, it's around about 56 cases. And then if you go, there are cases and have been cases in Germany, and there are cases in the UK and so on, but they're down to almost single figures. And I think that's a good indication of, well, okay, there's the US, it's still out there. China, no, it's a real issue in China because of their great technical expertise in AI and their, rivalry with the US in terms of technological leadership in AI. So I do think we're going to need to pay a lot more attention to China, first of all, but other jurisdictions also in this interconnected world, whether we think there is deglobalization going on or not, we are interconnected, and these issues, especially with digital technology, are going to be everywhere. And we're going to have to be much more conscious, and I think we are, of international practice, international in the sense of different jurisdictions.
Thanks. So next question relates to both confidential information and really how you have adroitly managed to navigate the remarkable technologies that have sprung up in the course of your lifetime, whether it's the personal computer, whether it's the internet, and certainly, as you just mentioned, artificial intelligence. So talk to us about, first of all, how do you keep an eye out for what is the next big trend? Well, in your case, it was confidential information, and our viewers should know that not only were you a great student of confidential information, you have produced a multi-edition treatise on the subject, which still continues to guide our learning in that area today. But the second part to that is that navigation of new technologies, especially for people who are anxious about how do we get our grips on AI. People sometimes say, well, we've done this before with all the other technologies. So please share your thoughts on this.
Well, I think that is the beauty of intellectual property. It's like a window onto what's happening in the world. And that applies to, of course, technology, which we see through the patent system, because the basis of all intellectual property really is novelty, one way or another, whichever way, novelty, originality, whichever way you express it, it's something new. So we have, in being intellectual property practitioners, we have this wonderful window into what's going on in science, technology, but in the creative industries. You know how the creative industries are adapting to the digital transformation, going from vinyl to streaming. We see it all happening through copyright. And that's, I think, one of the remarkable things about intellectual property, that makes it such a great discipline. And the same with design, whatever it might be, plant varieties, you name it. How do you keep up with this? That's a real challenge, and I'm finding that to be a challenge. I try to keep up, you end up. I spend a lot of time reading every day now. In fact, I spend more time reading now than I did when I was Director General at WIPO. I didn't have the time to do the reading then. But there's so much happening, and there's so much going on in science. Now, what's the next big trend? Well, that's again another byproduct of the intellectual property system, is that the patent system gives you wonderful statistical insights into which fields of technology are moving and where they're moving, which parts of the world are moving, and with which firms, which companies they're moving. So this is a great source of economic intelligence that we have in the patent system, and really a wonderful contribution made by the patent system. My money is on biotech. Now, we've been saying that for 30 years at least, if not 40 years. And of course, the whole world is focused on AI at the moment, and almost to the point of an obsession, but or a fetish about AI. But that's that, and I think probably justifies that level of scrutiny and interest. But what's happening more quietly in the background with respect to the whole field of biotechnology and genetic manipulation, I think that is going to be just a massive transformation for us as human beings, equally as much as AI. That's intelligence, but what about our bodies and what we can do with intelligence, and what about brain-computer interface and the junction of biosciences and AI? That's where I think we're going to run into the deepest ethical problems and questions about what it is to be human.
Thank you. Lots of food for thought there. So coming back to the time that you finished your doctorate, did you know what you wanted to do next?
Look, as I think I said already, yes. Most things happen to me by accident rather than design. I don't claim that having foresight. I didn't. So I started off as an academic, and then, WIPO was a natural place. I had visited it during my doctorate to see it, and I was interested because of the economic analysis in the patent system, and in particular in technological progress, what was happening in terms of the seizure of consciousness around the world, that actually innovation was the great driver of economic growth. Now, you can go back to the 1950s for that, was Solow and Robert Solow and technical progress, as they then called it, and the residual factor. But it started to take off in the 1980s, I think. And you actually see that in patent statistics. If you look at a 100-year graph of patent, or a 120-year graph of patent statistics, you see that for 100 years, patent statistics flatlined. From about 1880s through to 1980s, it's a flat line amongst the top patent offices of the world. Very little growth in demand. And then suddenly in the 1980s, it takes off. And you get it taking off in the United States, in European countries, in Japan, and then in China, and then in Korea. And you see that very clearly, and then, other countries in the rest of the world. So I think that innovation, really hit the road in a major way in terms of consciousness of the world in the 1980s, which coincided with the digital revolution also.
So was the digital revolution responsible for that catalyst?
I think it played a big part. It played a big part because people were obviously fascinated with computers, and having personal computers, which came on at that time, was something extraordinary. Before that, it was really scientists delving into computers, but having personal computers, and then of course the 1990s, and in particular 1995, the authorization of commercial activity on the internet, just a big explosion there. And that brought it to every single person that was fortunate enough to have the financial means to be able to own a computer. And these days, it's, of course, a smartphone, and internet connections are around about, according to the International Telecommunications Union, around about 68% of the world. There's still 30% left out, but 68% of the world's population of 8-9 billion are connected to the internet.
So looking at the 1980s to today, are we still on the up and up, or do you think we have peaked and we are now going downwards?
I think we're still on the up and up because there are untapped populations, as I mentioned, and artificial intelligence is making us, if anything, use more digital technologies or use digital technologies to a greater extent. So I think we're still on the up and up.
Great. So you've been, as I mentioned in my introduction, through an impressive and inspiring, or even amazing, I would use that word, series of roles at WIPO. I don't think anybody else in the history of WIPO probably has that same varied portfolio as you have. So take us briefly through in chronological order, one shop to the other.
So I started in the, thank you for your very generous comments. So, they're exaggerated, of course. But I started in the Asian Bureau, the Bureau for Asia and Pacific, which was Development Cooperation. And that was, again, a stroke of fortune for me because that was 1985, and I worked there for 3 years. Now, in 1986, the Uruguay round of multilateral trade negotiations got underway. And the United States of America put intellectual property into the Uruguay round for the first time. There had been some stuff on counterfeiting previously in multilateral trade negotiations, but intellectual property came in. Now, the world was, as we mentioned earlier, of course, this was the time digital technology transformation was starting to occur. Technology was on the uptake generally. Consciousness about innovation and the importance of innovation and its position in giving competitive advantage. But many Asian countries didn't have a clue about intellectual property. Some of them had old colonial statutes, for example. And so you had some quite sophisticated countries, where the Ministry of Foreign Affairs was suddenly coming along to the Patent Office, which typically was buried somewhere in the backwaters of the bureaucracy, and saying, hey, what's this intellectual property about? Because bang in the World Trade Organization was a very controversial issue about intellectual property and having a comprehensive normative agreement on intellectual property. So the activity in those countries picked up, and we were extremely busy in trying to, make a contribution to the formulation of understanding and policy in relation to intellectual property for multilateral trade negotiations. And then that spilled over, of course, back into WIPO. And then I went from that into what was then really the treaties section, where we were working on patent law harmonization, trademark law harmonization, a rather disastrous exercise on integrated circuits for semiconductors. And
what made it disastrous?
Well, I think that the sui generis protection of layout designs for integrated circuits basically has been a failure. It hasn't really been used. It's a bit like the sui generis database right that the EU pioneered. I don't think that they have been successful exercises, and it's very interesting from intellectual property point of view. We're not very good. We are what we do usually is adapt the existing systems, copyright, patents, trademarks, etc. Inventing new ones we're not very good at, and that's going to be important in relation to AI, and we may come back to that. But so I was there, and those were fairly difficult discussions always, because the organization was in transition from a purely technical organization, which was dominated by the developed countries, into one with a much broader membership, more and more developing countries, and one in which down the road at the WTO, intellectual property was a hot issue. And countries like, the size of India and Brazil were saying, hold on a minute, let's not get too carried away with this intellectual property. So that really started a process of the politicization of intellectual property, I think, internationally. And then you go fast forward a few years, and I then, found my way. I worked in the Director General's office for a couple of years, and then found my way eventually to the Arbitration Centre, the founding of the Arbitration Centre, and from that to legal counsel. And I started as legal counsel at the time when the 1996 copyright treaties were concluded. And that's a good example of how the world of IP internationally changed, because typically a diplomatic conference to conclude a treaty at WIPO involves some 200, maybe 300 persons. Suddenly, there were like 700 people or 800 people at this conference, and all sorts of organizations like the United States Telephone Association were suddenly lobbying to have observer status for this. Why? Because of the internet and because of intermediary liability. And they were saying, hold on, common carriers, no liability. We don't want any liability for intellectual property infringement. Suddenly, intellectual property burst internationally into, as a result of World Trade Organization, developing countries saying, hold on, we want to have a word in this. And the technology being everywhere and having massive consequences, it burst into a question of fundamental importance.
So take a step back. People should also know the pivotal role that you play in founding WIPO's Arbitration and Mediation program. And I should say that Penn State Dickinson Law is a proud partner of that center, and we partner with folks there every year to have seminars on dispute resolution around this country.
Indeed.
So once again, you're almost like a startup founder, Francis, because you lock on to the next big thing, and it in fact does become the next big thing. And arbitration and mediation is, something that everybody is talking about today. Back then, people weren't really talking about it, but you thought it was important. So tell us a little bit about your thoughts there.
Well, starting with arbitration and mediation, the impetus for that was, I think, first of all, that it's a technical subject matter, WIPO, and a lot of arbitrations or the practice of arbitration came out of technical subject matters, shipping, maritime, etc., where you needed specialists. So intellectual property was a bit of a given. And then intellectual property, of course, is international. It's exploited worldwide. And so you have the possibility, indeed the reality, of multi-jurisdictional disputes, and a single mediation or arbitration procedure gives the opportunity to settle it, if you want to settle it with one procedure rather than a multiplicity of national litigations. So that was the background. And then along came the domain name system. Well, along came the commercialization of the internet in 1995. We started arbitration in 1994. And then when the commercialization of the internet occurred, the United States government wanted to devolve the management of the domain name system onto an entity which was yet to be born and which has now become ICANN. And they wanted it managed by ICANN, the domain name system. But there was nothing really there. or not much. It was done by John Postel and a few others, and then Network Solutions, but as a monopoly, as it were, and it had to be internationalized as well. Now, one of the barriers was that a journalist in Chicago actually registered McDonald's.com because there was no guardrails. It was not like a trademark registration where you have a system for filtering. Suddenly industry said, hold on, this is a real problem. And they said, we're not really happy about going forward with the devolving of the management of the system, the domain name system, unless we can solve this trademark problem. So the United States government actually came along to WIPO and said, can you conduct an international process which will come up with a solution for this? And so we did that and published a report recommending the Uniform Dispute Resolution Procedure, which was adopted. And that was a very interesting exercise because it required a piece of legal engineering. The problem was that normally the classic response would be, oh, let's have a treaty. But things were moving far too fast for a treaty. A treaty on a very, very fast track would take 3 years to negotiate. And 3 years in the internet with people registering domain names all over the place would create such chaos and such a mess that it was not possible. So the solution was to rely on contract and the engineering of contract. So ICANN, which then was born after another 6 months or so, 12 months after a process, ICANN contracted to authorized certain registrars to receive registrations for domain names. And a condition of authorizing their registration was that the domain name, contractual condition, domain name registrar agreed to abide by the results of the Uniform Dispute Resolution Procedure and to submit all its registrations to that procedure. And then the domain name applicant comes along, says, I want to register x.com, whatever it is, and a condition of registration is that the domain name registrar, domain name applicant, submits to the Uniform Dispute Resolution Procedure. So everyone's contractually bound to respect the Uniform Dispute Resolution Procedure and its results. And that way, we got a coherent system internationally, which worked. And now, we're on 80,000 domain name disputes later, administered by WIPO Arbitration and Mediation Centre. Last year, 6,200 or so domain name disputes. 80,000, 70,000 of them the general GTDLDs and 10,000 of them in the CCTLDs. So it's been really a very enlightening experience and fortunately a great success. And what's enlightening about it is that it's made us very aware that the treaty is not the only way to go in terms of international cooperation. In fact, I think one of the things that occurred to me during my time was, okay, geopolitically, this is all becoming a little bit more difficult, especially for treaties, because you have to go through before congresses and things for approvals and so on. Platforms can be as effective as treaties. So not just treaties, there's still a role for treaties, but not just treaties, but platforms. WIPO dispute resolution procedure is one example, but there are other examples. If I may take, and stop me if I'm talking too much, take the Marrakesh Treaty, which we perhaps haven't come to, but it's a treaty, as you know, to facilitate access, you've mentioned it, to published works for blind persons and other print disabled persons. Now, that creates the possibility for an accessible format work made under an exception in one national jurisdiction to be used in another national jurisdiction, which may have an exception, but the accessible format was not made under their national law. So it creates interoperability between exceptions for making accessible formats. Now, what the treaty does is create the possibility of movement. It doesn't move one book. To move the books, you need what we established, which became the Accessible Books Consortium. And that was a public-private partnership of all relevant stakeholders, namely the World Blind Union, the publishers, the rights-owning organizations, the libraries, distributors, all coming together and saying, okay, we're going to make this work. And the result is, through the Accessible Books Consortium, that there are now over 1 million books in publications in accessible formats in 80 languages, which blind persons, subject to the conditions of the treaty, are able to have access to all around the world with digital technology. So it's a great example of how international cooperation has evolved. The treaty, but the platform, extremely important. And both of them working together in conjunction creates a wonderful, solution which is much more comprehensive than could be obtained through just a treaty. And there are many other examples of public-private partnerships that we established on platforms, digital access service. I'll give you just one other example because I'm talking too much. You used to have to file a priority document for a patent. You used to have to file the priority document in every jurisdiction in which you filed for a patent, applied for a patent. We established something called the Digital Access Service, in which the applicant files one copy of the priority document with WIPO, and any country in which the applicant later applies for a patent claiming priority, the applicant only has to cite WIPO's reference, and the Patent Office can go there and download the priority document. One document instead of filing 80 or however many according to your jurisdictions. So you can do a lot through practical platform cooperation. There are, as I said, many other examples. I'm talking too much. I won't give you the other examples. But this was really exciting work because it's creative work with new instruments and new ways of finding international cooperation. And I think that international cooperation nowadays needs this because of the geopolitical blockages.
Thanks. I think you have made the case for yourself, Francis, that we won't have enough time under the normal parameters to finish. But if, with your permission, can we extend our conversation by another 15 or 20 minutes?
With great pleasure, Daryl.
Thank you. Because I certainly want to get through all these things which I think really attest to your remarkable journey. So 2008 was a significant year for you and for the world. You became Director General of WIPO, and the world was going through a huge financial crisis at that time. But take us a step back from there and talk about the road to becoming Director General, and then your first day in the office with all of what's going on at WIPO and the world.
Well, Daryl, what I would say is that, and this is very inconvenient for everyone else, but I've always found that when I finish a job, I feel qualified to start. So, as I said, that's not very convenient for anyone else. But so I went in, and even though I'd worked in the organization for a long, long time and had indeed been a Deputy Director General, it's not the same as being Director General. And, the famous saying, the buck stops here. So it is different. And you have to learn. You have to learn on the job. I mean, I make no bones about that. You don't go into it. Some people might go into it, as a well-oiled machine, but I didn't, I don't think. And you learn on the job. And there was a lot to be done because there was quite a lot of stuff. In fact, I think the three main tasks that I set for myself, the organization, as it were, at least the secretariat, in the first period were returning the technical focus of the organization. WIPOs are specialized agencies. IP is not blah, blah, for all of the reasons that we've already discussed about, how intellectual property was becoming a very central factor in the economy and in international competition. For all of those reasons, IP is, it's very serious. It's an essential, although not sufficient, element in a healthy innovation ecosystem. And since innovation is the basis of competition in the contemporary economy, and intellectual property protects the competitive advantage given by innovation, or creativity for that matter, then you have to be technically focused on something that is very serious subject matter and it's not blah, blah. So returning the technical focus was one task. The second task was management, putting in place proper systems and best practices, and not hocus pocus. And a third focus was digital transformation, bringing the organization out of, I know it was fairly late, but bringing the organization out of the analog age and into the digital age. That was a long process, and we managed to do it, digitized everything, and even, pioneered some AI applications like speech to text for meetings, which, immediately transform reporting and everything else. Search, design search, for example, trademark search on AI, translation, which is AI is the basis of translation, even if there's still human refinement at the end. So those were the three focuses. I think you have, one of the difficulties is that, of course, the owners of the organization are the member states, and the member states can be impatient. And these processes that I've just mentioned take time. You can't do them overnight. And so it's a trade-off between, on the one hand, a systematic, thorough approach, which takes time, and on the other hand, quenching the thirst of these dogs at the door who are saying, yeah, what have you done? What's happened? We want results, and we want them now. So the first 2 years were difficult, because you don't have results in the first 2 years.
What about the dogs inside the door, the people that were working in the organization? How did you manage the change there?
Yeah, that's a great question. And, to be perfectly honest, some member states were kind enough to warn me, say, look out for change management. It's going to be a big impact to the organization and so on. And I did not pay enough attention to this, I must say, I must confess. I eventually, with the help of colleagues, got onto this, and we, I think, ended up in a good place. But initially, I did not spend enough time explaining and enough time with the staff, taking them through, well, we're about to go through a big transformation. That was, I think, something that I could have done better.
So there were two parts to the question. You answered the second part. The first part was, how did you, in fact, become Director General? What's the process like? And why did you want to become Director General?
Well, I wanted to become Director General because I spent my life in that organization. I thought that I had some things to contribute, and my specialty was intellectual property. So I thought, okay, I might as well have a shot at running this show. And then how did this happen? Well, that process is a rather horrific process, actually. You have to get the nomination of your government, and it puts you forward. And there were 16 nominees in the election of 2008. So it's quite a significant number. And it was, a really heart-stopping election because, well, before the election, you have to go around and explain your case to all of the members of what is called the Coordination Committee, which is the body that it's 87, I think, or 83 members rather, 83. the body that elects, nominates the Director General. The General Assembly approves the nomination.
I always thought that, just as a footnote, it's quite humorous that the organization with so much power has a name like Coco.
Indeed. And as Asia becomes more prominent, it's even more humorous. Yes.
Please continue.
Yeah. So that you go around, you plead your case, you say why you think you're qualified, and so on and so on. And decisions are made on a basis of by member states on a basis of geopolitical loyalties and merit. So obviously there are alliances, there are groups, and people prefer first a candidate from their region, and so on and so on and so on. But at the same time, they have an eye on the interest of the organization, and they're interested in merit. So that, one member state actually said, typically in the early rounds of an election, geopolitical loyalties are more important, and in the last rounds, merit becomes more important in our consideration of for whom we should vote. And I found that very interesting insight. But then you come to the election, and the election took place over 4 rounds. And after the first round, there are dropouts and also expulsions, if you like, from the list of 16. And then after the second round, you go down to a reduced number. So by the end of the second round, with dropouts and compulsory withdrawals, we were down to 3 persons. And for the third round. And if I remember correctly, one had to have 42 votes to win. And if I remember correctly, I had 35 after the third round. The Brazilian candidate, José Graça Aranha, had 27. And Pakistan, the ambassador of Pakistan, who was a great candidate, had 19. And he had to withdraw because he had the least number, which left me and Brazil. Me with 35, he with 27, and 19 coming to be redistributed. Now, geopolitical loyalties would suggest that the 19 would go to Brazil. That is a developing country, rather than, because they were votes for a developing country, rather than to a developed country. And so, there was a good deal of pessimism, I would say, in the Australian camp before the final vote, and quite a bit of optimism in the Brazilian camp. So we went to the vote, and the votes counted one by one, and it was heart-stopping, because we got to 40 each votes, and you had to have 42. And then there were 3 votes left, and it was 41 Gurry to 40. And then, through some stroke of chance, the second last vote was again Gurry, so it was 42-40. And the last vote was Brazil, so it was 42-41 we ended up with. And I haven't heard in an international meeting a sigh quite like, when the final result came out, because everyone was sitting there breathless at this. So it was quite exciting, really.
Did you celebrate?
Yeah, sort of. You get over the shock first.
Somebody should make a movie out of this at some point, or you should at least have a autobiography. Anyway, this paves the path for it, I hope. So you take over as Director General, and you talk about the changes that you had envisioned. The thing about WIPO is it's not just a international body, it's also a service organization, and you provide all sorts of different services. Does those two roles come into tension with each other, you think, from time to time?
Yeah, I think so. I mean, look, take the wonderful assets of WIPO, the PCT, Madrid, The Hague, these systems, global systems that it has. Uh, you wouldn't, and even the arbitration center. I think it would be very difficult to establish them now in today's geopolitical environment. Very, very difficult. So that that acquis, as the Europeans call it, that uh, built history, 26 multilateral treaties, roughly, if I'm not mistaken, 26 these days. The data exercises that you've mentioned, the Global Innovation Index and so on, the statistics, and the development cooperation programs, these are all wonderful assets for an organization to keep it going. And WIPO is very fortunate there. Now, they are mainly technical operations. And now we face this very difficult and tense and uncooperative, really, geopolitical environment in which I think, there are many ways in which you could describe it, but I would say that there's always a bit of a tension between international competition and international cooperation. And right now, it's out of skew. It's all international competition and very little international cooperation. And we have to rebalance that a bit to get international cooperation back again. If I may, I mean, I think I'll quote someone, Antonio Gramsci, who was imprisoned by Mussolini in the 1920s. And he wrote a series of sketches or books called The Prison Notebooks. And in it, he says in 1929, he says, the problem is that the old order is dying, but the new order cannot be born. And in the interregnum, a great many morbid symptoms appear. And I think that describes perfectly the current situation for multilateral and international cooperation. Sorry to be so pessimistic, but I think we have to be realistic. The old order is dying. The new order can't be born yet. And in the interim, we have these signs of morbidity all over the place, which we're painfully experiencing. So, of course, everyone around the world is scratching their heads about this and wondering how to do it. I take consolation in the fact that in the 19th century, 4 international organizations were born. They were in technological order, actually, as well as chronological order. The Universal Postal Union in the 1850s, the International Telecommunication Union was the Telegraph Union then in the 1860s, World Meteorological Organization, all under different name, 1870s, and then WIPO, the World Intellectual Property Organization, under a different name in the 1880s. Now, those 4 organizations have survived 2 world wars, the birth and death of the League of Nations, and the decline of the United Nations system. And arguably, or at least I would argue, they still do a good job, and a very good job. And it's a testimony to the strength of technical international cooperation as opposed to political international cooperation. Where we run into problems always is political international cooperation. So for me, the task for a specialized technical agency like WIPO is keep your eye on the ball, the technical focus. That's what experts, you put experts together, they agree. They speak the same language. You put politicians together, it's a different story. So, but the difficulty is, as we've discussed, that intellectual property is increasingly politicized because of its central role in the innovation ecosystem and because of innovation's central role in competitive behavior economically.
Thank you. So let's talk about the 2 treaties that people think about when they think about your term as Director General. You talked about the Marrakesh Treaty, and there's also the Beijing Treaty. The Marrakesh Treaty seems to be particularly interesting because it was not really, or at least on its face, economic in the way that it was designed. The Beijing Treaty, well, for audiovisual works, rights of performance and audiovisual works, has more of that. But I think what was also special about that treaty was that it was named after an Asian country, a
Yes.
capital in an Asian country. So talk to us about those two aspects of the treaty, the non-economic aspect of it, why that was something that you wanted to focus on, but also the significance of the Beijing Treaty being called the Beijing Treaty.
Yeah, so I mean, the first one, I think it was a problem crying out for a solution. There was what we used to call the book famine. That is that only something like 5% of newly published works were becoming available in accessible formats for blind and print disabled persons. So that was an obvious solution, and it was taken up, and we must give credit to them, by the NGO community, really. And it was taken up by the World Blind Union, by organizations like the National Federation for the Blind in the United States of America, a wonderful organization, and by some other NGOs internationally that saw this issue and saw it as a possibility. Then there was some pressure from, some of the developing countries which were wanting to, I'm using their terminology, rebalance the intellectual property system to place a little bit more emphasis on exceptions and limitations and a little less emphasis on strengthening protection. So that was there lurking in the background. But that, of course, made it difficult for the developed countries, for whom now, intellectual property was a major means of protecting their primary competitive status. That agenda didn't, go down extremely well. So you had this collision of all these different interests, and some of them were economic, not in the sense that this exception was so very prominent economically, except for the publishers, but for the rest of the intellectual property. But they could see the implications. Okay, you have an exception for this, and now what are you going to have an exception for next? So that was the sort of background. And I think what happened at Marrakesh, at the time, people were calling it the miracle of Marrakesh, because we were not optimistic going into the diplomatic conference. There were still important states who were against the idea of a treaty, and they had to come round. And something happened in Marrakesh that brought everyone together. And that was a really wonderful experience, because you had, at the end of the day, member states, the NGO, member states of all political complexion, the NGO community, and all the stakeholders, the publishers, and that finally coming together and saying, "Okay, we'll do this." And it was a very moving experience, I must say. So now for Beijing, well, yeah, you're quite right. All of our treaties were, Paris Convention, the Penn Convention, the Locarno Convention, you name it, Strasbourg Convention. They all have the names of mainly European cities. PCT is actually the Washington Convention or Washington Treaty. And so the South was notably missing. There was one, the Nairobi Treaty on the Olympic symbol, which came along. But then we had the Beijing Treaty, and that was great. It was wonderful, because if you think of the enormously profound cultural richness of China across 5 millennia, enormous cultural richness. It was great to have a treaty focused on cultural expressions, creative expressions, namely audiovisual performances here. That was concluded in China, first of all, and great to have it named the Beijing Treaty, which, was from a country of the South, as it were. And that, I think, was really very, very pleasing, and it started a trend that is continuing because we've subsequently had not only the Beijing Treaty, but Marrakesh from Morocco, and the Riyadh Treaty on Designs in the last 2 years. So that's nice. It universalizes intellectual property.
Great. So you then come to the end of your first term and you need to decide whether you're going to run for a second term. Walk us through that thought process and that journey from term number 1 to term number 2.
Yeah, so there was, of course, unfinished business. And you feel that, of course, there's always going to be unfinished business, even if you serve 30 years. But there was unfinished business. I didn't think that I was stale. If I had thought that, I would have jumped out. So I thought a lot of the things that we had managed to do in terms of, digital transformation, the changing of management systems and so on, were still in the embryonic stages and needed further guidance and work. It's true that the geopolitical situation was becoming more difficult. My second term started in 2014. Well, the United States under President Obama changed from strategic cooperation to strategic collaboration to strategic competition with China in 2016, if I'm not mistaken. So new ball game, and things were that was already brewing, of course, and the world geopolitically was changing, and that was true right across the multilateral system, and the center of economic, demographic, and increasingly technological gravity was moving towards Asia. So instead of having predominantly technological competition between Europe and North America, with Japan coming in the 1970s, 80s, you had China from the 1980s onwards, and then Korea, and then, of course, Singapore and other centers around Asia. And it became very much a tripolar world rather than a bipolar world, speaking technologically, not politically or just politically. And it became a tripolar world technologically. And as you know, now, 2/3 or more, nearly 70% now, of all intellectual property applications are filed in Asia. That's extraordinary. Nearly 70% of all intellectual property applications are filed in Asia. How can you, not pay attention to, and demographically, it's the biggest market in the world. So if you're, inventing things and commercializing them, you're looking to Asia too. So this was it's really, I think, sometimes wonderful to have witnessed this, because this is once in every 100 or 200 years event. We can see in retrospect things moving from Europe to North America, and Asia coming into the picture in a massive way, led by China. So it was a very interesting environment, but difficult.
You didn't talk about the votes for your second election.
Well, there were candidates who opposed me, and I think 4, if I'm not mistaken. I won on the first round. So I think you had to have 42, as I said, and I think in the first round I got 47.
Which I think speaks to the confidence of the member states on your first
Well,
term.
that's That's very nice of you to say,
Yeah.
Daryl.
So during your second term, WIPO and your leadership were subject to public controversy and institutional criticism. Without revisiting the particulars of the disputes, what did that experience teach you about institutional trust, about transparency, and about accountability?
Yeah, well, look, I know you don't want to go into the details, but let me say there were four main items where a complaint was lodged. And I do want to say that all four were dismissed as unsubstantiated. And if anyone doubts that, I'm happy to furnish them with the proof of the authoritative instance that decided this is dismissed. There's no evidence, there's no blah, blah, whatever. So that out of the way, what did it teach me, the experience? Well, I don't know whether I handled this particularly well. I'd say the first thing it taught me is the importance of the rule of law. You know, at the end of the day, we rely on the law to regulate controversies and disputes. And we agree to abide by the rule of law and not of politics and not of gossip or, irresponsible media. Not that all media is irresponsible. But at the end of the day, you have to have an authoritative instance, which might be the chairs of the General Assembly and the Coordination Committee. It might be United Nations Security Council for questions on sanctions. Whatever the authoritative instance is, it considers all the evidence, it takes a decision, and we abide by the decision. Now, some people are bad losers, of course, and they like to go around, make noise, and so on. So the second thing, besides the importance of the rule of law, that it taught me is that we have very mixed media. We have some wonderful media, some truly wonderful, what were called newspapers around the world, and journals, and increasingly now blogs and the blogosphere. We have some really wonderful, conscientious, objective media, but we also have some trash, real trash that can be manipulated, whether for money or favors or access or whatever it is that they're being manipulated for, or who are ideologically bent, so that's the part that I don't think I handled very well, is how you deal with this, rampant media, some of which don't touch the stuff. I could name you, five or so newspapers, Financial Times, New York Times, South China Morning Post, Straits Times, a few others like this. They never went near any of this stuff.
Mm.
But there was plenty of activity and plenty of others out there doing it. So the second thing it taught me is you need the rule of law to make the final decision, and we should abide by it. But you've still got good media, wonderful media, but you've got some crap out there, some rubbish and trash, which is able to be manipulated for political purposes. We see that all the time. Yeah. And so managing that's very difficult, and I don't think I've managed it particularly well.
Well, given that this is a series on leadership, I think it's something which people who are not leaders don't often think enough about. Leaders are, by definition, there at the top, and their actions, their words attract media attention. And I hope that when people hear this, they're going to be a bit more savvy about this dimension about leadership as well. Now,
yeah, and I think, Daryl, that one of the problems is time.
mm-hmm.
You don't have the time to be attending to, a lot of that stuff because you've got to get on with your work. So that's an additional challenge for a leader, and maybe, they need to bring in someone professional to help in that management.
Absolutely. So at the end of your time there, COVID happened. Talk about how COVID has changed both how WIPO worked, its processes, but also how did you guide the organization through that period?
Well, it was a challenge for everyone, of course. I only had about 9 months of the COVID experience, because COVID really got underway March 2020, even though the first cases were November 2019. But the sort of generalized pandemic element was March 2020. And I finished at the end of September. But in that time, we had to send the organization home twice, because we started to bring them back and then we had to send them home again. And we had to invent which everyone was doing, the management methods for dealing with the work of the organization and keeping it going. And that involved, of course, we were fortunate to have digital technology. I don't know what we would have done without digital technology and the internet in those days, but that involved new management techniques. But it all worked remarkably well. It's easiest where you have quantifiable goals. So, for example, translators in the PCT have a certain number of abstracts, summaries of a PCT application that they have to translate per week. And whether they do that at home or at work, you can quantify it and you can keep a measure over it and have an indicator about it. And the same with processing PCT applications or Madrid applications and so on. So we're fortunate in a large part of the organization, we have quantifiable management indicators. But in some other areas, it's much more difficult. For example, in the normative area, you couldn't have meetings, no physical meetings, or development cooperation. You couldn't get out into the field. So these were much more difficult to deal with. There, I think you have to try to use techniques of communication. So I used to have a meeting during that 9 months period, once a month, with the heads of about 20 offices once a month, and we would touch base and say, and I would report and say, well, this is what's happening here. And then each of them would report and say, this is what's happening here, this is what we're doing. And not only report and so on, but also comment on why don't you do this and why don't you do. They were immensely helpful. The heads of IP offices were fantastic. They were great because you can't do it on your own. You don't have the experience, the know-how. You have to rely on cooperation, and that's what you're there for, international cooperation. So that was remarkably helpful. Now, the other aspect was the storm brewing over IP, intellectual property, and the age-old question of access to medicines. And we know that was a pretty messy situation. But WHO, the World Health Organization, went out very early on, like March 2020. That was when it just started as a pandemic. And they accepted what was called then the Costa Rican proposal, because it was proposed by the president of Costa Rica. And the proposal of Costa Rica was to confiscate all intellectual property. And if you read the actual provisions, all data, all inventions, all trademarks, all designs, everything, to confiscate it all and to share it, all relating to COVID, and to share it. Now, I thought that was wrong. And I thought it was wrong primarily as a question of timing. There was nothing to share in March 2020. You were slicing up a non-existent cake. And not only that, but you were putting up, and people will disagree with me about this, but we each have our own view, but you were putting up a massive barrier to innovation by saying, by the way, if you invent anything, you're not going to be able to control its commercial exploitation. That there should be, in a pandemic, government surveillance of the commercial exploitation of these matters of inventions and innovations, fine. But let's see what we've got before we decide what sort of governance system you want to put in place. So I think WHO and its Director General went out on in a false path in going, and their measure didn't go anywhere anyway. And so I published a statement at that time. I consulted a bit with some member states and published a statement saying just that. I don't think it had much impact, but anyway, it got it out there. Then things went on, and it became a rather messy situation because you had health ministries, entirely understandably, saying the priority is health. So we don't care about other, economic problems. But you had economic ministries saying, hold on, we not only are going to have having a massive health crisis with human suffering and death, but we're going to have a massive economic crisis with suffering resulting from the economic crisis as well. So, as ever, for me, intellectual property is a question of balance.
Yeah. Why wasn't there, you think, on hindsight, more coordination between WIPO and WHO?
Well, I think, health ministers go off on their own, and they're not necessarily interested in hearing about someone who's going to put a spoke in the wheels.
Well, and the leadership position between the Director General of WIPO and the Director General.
Well, it just didn't happen. I'm sorry. There were attempts, but it didn't happen. And that's a pity. That's a real pity. And in fact, as you know, there has been a pandemic agreement or treaty concluded since, which seeks to regulate some of these questions. But for me, one of the dimensions that's missing from the pandemic treaty is a coordination mechanism with other agencies.
So you finish your term. Talk about finding significance in the current chapter of your life.
Well, it's great. By the way, it's really very nice to have the time to do a little bit of reading, and I'm consulting and working with various organizations, mainly in China, but also in Australia and a little bit in the Middle East and around the place. So I'm enjoying it and teaching in various institutions, including in the UK. So it's a very mixed bag, and I couldn't be happier than with all those connections that I have, and that make me try to keep up with things. And it's good to step back. Now, a paradox is that, I'm probably have more time to follow and learn about intellectual property than I did when I was Director General of WIPO. And of course, that's a very, undesirable thing, but it's inevitable because when you're Director General, you're concerned with management. A lot is concerned with management, and a lot of management is human resources. So you can't get away from it. And then you have member states. You have 192 clients that all want personalized attention, and you have policy, and so you really are under the hammer. But now it's a much, a time where I have much more time to think about things, and I'm enjoying it immensely.
And for people who are planning for their post professional life years, I suppose in some ways your professional life continues just in a different form. Do you have any advice for them?
Well, I think, my transition was a bit messed up by COVID because my idea was to go and spend 3 months somewhere in Asia. I couldn't move out of my house, my apartment. So I didn't have the normal. But I think a good thing is to go away. Maybe not 3 months, but go away for 2 weeks, so that you don't wake up the next day and say, "Oh, I don't have to go to work. What do I do?" You have to plan it, and preferably go away for a period of 2 weeks or a month or something to change, so that when you come back, you're in a different mood. And I think we don't make enough use of retired persons, retired from full-time employment. Now, I know that's a difficult question, because youth unemployment is a big problem, and we don't want old people occupying all the positions. So, and then we also have AI with the threat or menace of employment replacement. So it's tough for young people now. But nevertheless, there are a lot of things that retirees can do, such as teaching, or even depending on what you're doing, childminding, whatever. We're going back to the conception of the family, which is not maybe the nuclear family of that emerged after the 1950s in many Western countries. And we're going back to this, multi-generational style family, where, because there's so much pressure on young people, a child will have 4 or 5 parents, including the grandparents and so on. So I think there are a lot of things that that old retirees can do, and their experience is valuable. And the sort of roles that I take on are teaching or consulting, trying to give advice which is somehow helpful and hopefully benefiting from my experience. So they're not executive roles. And the executive is left to those who have the energy and the enthusiasm and the youth to be able to do it. So that's how I would see it. And keep active, go for it.
Great. Last question for you. Looking back at your life, what are some of the things, maybe 1 or 2, that you are most proud of?
You're talking about my professional life.
Take it however you like. You have the last word on this, Francis.
Well, on personal life, I must put family as number 1. But moving off personal and going to my professional life, I would say that I've had a lot of good fortune, because I came into, once I was on a panel in San Francisco, actually, in San Diego. It was the bio conference, and there was an anchor from San Francisco, and there were 4 or 5 of us. And he said, "Oh, you came into intellectual property in 1985. It's actually a little bit before. And nobody knew anything about intellectual property there. And now it's the flavor of the month. Did you foresee it?" And I said, "Well, no, and that's why I'm a bureaucrat." So I think I've been fortunate. There was a conjunction that occurred. Maybe I had a little bit of insight, but it was more luck than insight, I'd say. And I think I'm really pleased to have been able to watch intellectual property grow in significance, and really pleased to have been a part of what was a truly, combined international effort to give birth to the Marrakesh Treaty and the Accessible Books Consortium. And I'm personally, if I may be a little bit immodest, I'm personally very proud of the insight of platforms, not treaties, in the digital age.
Well, thank you for this very thoughtful, very generous conversation. We are so deeply grateful for your leadership, for your example, for your contributions to the law, to international cooperation, to the institutions that support innovation and creativity, and I should add entrepreneurship around the world. Thank you for joining us on this episode of Profiles in Leadership.
Well, thank you very much, Daryl. It's really been a pleasure talking to you, as always. We're good friends, and really a pleasure and a privilege to be on your program.
Thank you.